Good morning. My name is Julie Carlson. I am the Associate Director of the Schumpeter Project on Competition Policy at the Information Technology and Innovation Foundation. Welcome to the latest installment of the ITIF's Dynamic Antitrust Discussion Series. So earlier this year, the Federal Trade Commission and the Justice Department's Antitrust Division announced plans to revise the guidelines regulators use to review mergers. Chair Khan of the FTC has stated that this inquiry is designed to ensure that our merger guidelines accurately reflect modern market realities and equip us to forcefully enforce the law against unlawful deals. AAG Cantor has said that we need to understand why so many industries have too few competitors and to think carefully about how to ensure our merger enforcement tools are fit for purpose in the modern economy. The agency's request for public comment asserts that the guidelines may not be adequate to equip enforcers to identify and prescribe unlawful anti-competitive transactions. This morning, our panelists, who are all former chief economists at either the FTC or the Antitrust Division, will discuss what basis there is for this assertion. Before we begin, let me briefly introduce the panel. So this morning we have Bruce Kobayashi, who is the Page V. and Henry N. Butler Chair in Law and Economics at the Antonin Scalia Law School at George Mason University, as well as Senior Scholar at the Global Antitrust Institute, and served as the Director of the FTC's Bureau of Economics from 2018 to 2019. Fiona Scott Morton is the Theodore Nierenberg Professor of Economics at Yale University School of Management and served as the Deputy Assistant Attorney General of the Antitrust Division from 2011 to 2012. Ginger Jin is Professor of Economics and the Advanced Professor of the College of Behavioral and Social Sciences at the University of Maryland and served as Director of the FTC's Bureau of Economics from 2016 to 2017. And finally, Howard Shalansky is a professor of law at Georgetown University, as well as partner at Davis Polk, and served in the FTC's Bureau of Economics as Deputy Director for Antitrust from 2009 to 2011, and as Director from 2012 to 2013. So I'll be saving some time at the end of the webinar today for questions from our viewers. So if you'd like to ask a question, you can go to slido.com and use the hashtag ITIF merger guidelines. All right, with those preliminaries out of the way. So before diving into particular aspects of the merger guidelines, I'd like to begin by thinking about the big picture and the purpose of the merger guidelines more generally. So Howard, you were at the FTC the last time the merger guidelines were revised. That revision has come under criticism with, for example, the American Economics Liberty Project saying the 2010 merger guideline revisions codified a more permissive approach to merger enforcement. So to start us off, can you talk about the purpose of merger guidelines and how the 2010 revision aligned with that purpose, and also whether you think the current call for revisions is consistent with the purpose of the guidelines?
Sure. Thanks very much, Julie. It's a pleasure to be here. I think that the purpose of the guidelines is to do a number of things. One thing is certainly just to let parties considering mergers have an idea of what kind of scrutiny they're going to come in for at the agencies. So when parties are contemplating whether or not to do a deal, looking at the levels at which presumptions of harm will be triggered, sort of concentration levels at which presumptions will be triggered is helpful to them. But also understanding the kinds of theories of harm that the agency will pursue and how they will think about those theories of harm. So how the agency will think about, for example, different kinds of coordinated effects that might result from a merger, or how they might think about the unilateral effects and what the combined firm might be able to do on its own. These are, I think, fairly important kinds of things to offer to the marketplace. I think they also let parties know how the agencies will consider different kinds of defenses that are likely to be raised. Power buyer defenses, efficiency defenses, things like that. So the guidelines certainly serve a public guidance purpose, but they also, I think, are a signal to courts about what lies behind the agency's thinking when it chooses to investigate and ultimately challenge a merger when it does so. The 2010 guidelines revision occurred for a couple of reasons. I mean, for one thing, the guidelines were 18 years old at that point. And there'd been a fair amount of experience with how the guidelines had actually been applied, both by the agencies and by courts. Now, obviously, courts don't apply them in the way that they apply precedent or law, but courts do incorporate them and cite them. So there was some learning about how they had been read and interpreted by courts, and a lot of experience with how the agencies were enforcing them. And I could see why somebody could look at the guidelines and at a very sort of superficial and structural level say, oh, the 2010 guidelines became more permissive because the HHI thresholds, the concentration thresholds that would trigger presumptions of harm were raised very slightly. So, the presumption of a concentrated market went from an HHI of 1,800 to an HHI of 2,500 and, things like that. But I think if one looks at the guidelines beneath that very surface kind of structural issue, one sees, first of all, that change in the guidelines, even at the structural level, was simply meant to align the guidelines a little bit with the reality of where courts were allowing the agencies to succeed in blocking mergers, and where the agencies themselves were actually enforcing through second requests, through merger remedies, and through challenges. So it was just a little bit of an alignment. In fact, it aligned only partially because the change did not come close to what the average HHIs were in enforcement. But looking beyond that, the guidelines really strengthened enforcement in a very considerable way. And in fact, the criticism of the guidelines at the time was that you've adopted these novel theories that are going to trigger challenges, all the time because of the new focus on unilateral effects and the broadening of coordinated effects to take into account unilateral but parallel conduct and things like that. So I think the guidelines really strengthen the theories of harm. And if you look at the people who participated in drafting those guidelines, they were bringing to bear a lot of learning and analysis that some of them, like Carl Shapiro and Joe Farrell and others, were responsible for bringing into the literature. And just a final note, Carl Shapiro and I have written a paper that shows what the impact was of the 2010 guidelines, or at least investigates it by comparing enforcement pre-2010, the decade pre-2010, and enforcement in the decade since 2010. And one sees actually no difference in the concentration levels at which there are successful challenges and at which challenges were, the agencies chose to bring challenges. But very importantly, there was a very big and I think significant change, which is that unilateral effects, which had been unsuccessful as an enforcement theory prior to 2010, became successful through cases afterwards that expressly cited the guidelines and the reasoning in the guidelines. So if you compare the district court decision in Oracle PeopleSoft, basically saying you can't have a unilateral effects theory unless you have concentrations at sort of section 2 levels of monopoly power, like, or market share, like 60%. In the H&R Block case, you see an express rejection of that and an adoption of the guidelines theory. So I think the criticism that the 2010 guidelines weaken mergers enforcement is incorrect on any kind of analysis below a superficial structural one. But for people who think that merger enforcement should be much more presumptively structurally based in a Philadelphia National Bank kind of way, one could see why they would want to tear those guidelines up, if you will, withdraw those guidelines, because those guidelines double down on economics and analysis and effects as being a relevant aspect of a merger investigation, rather than shifting the presumption the other way and say, structure should really be the driving force, and the other stuff should be something of a defense burden or receive less weight. position I disagree with, but I think it's the motivating force.
Yeah. So I guess how do you kind of view the latest call then to revise the merger guidelines? Does it sort of line up with sort of how you see the purpose and the need for revision that happened in 2010?
I think one can make a case that lines up very well with the purpose of signaling to the market. I mean, if the guidelines, as I suspect they might, become much more structural, much more skeptical of remedies, much more skeptical of efficiencies, and the 2010 guidelines became more skeptical of efficiencies compared to the 92 and more skeptical of remedies and more demanding of remedies compared to the 92. But if they go further in that direction, and also go further in the case of strengthening structural presumptions, it may not be guidance that that industry wants, but it will be fairly clear guidance. And in that sense, I think accords with the purposes of the guidelines. Whether those represent good policy judgments may be some of the things that we'll debate on this panel.
Yeah. And then I guess, I mean, the other point you made is sort of about how the guidelines kind of reflect how the agencies will review mergers. So does this sort of anticipated shift to more structural presumptions sort of reflect a shift that's happening at the agencies? Or is this sort of more aspirational in the sense that this is how we'd like merger review to happen, but that's not what's happening today?
Well, just a little of both. I do think that there is an aspiration to become more structural and more firmly structural. And, again, that's a policy judgment and one that can be debated. I do think in the marketplace, the agencies have limited resources. They have to pick their battles. And I have some sympathy for, the agencies when people criticize them for letting certain deals through and saying, oh, this shows you're not serious about what you're doing. Well, they only have so many people there. And I do think in the battles that they are choosing to fight, and in what I am seeing in the sort of practice side of my life, the agencies are taking a more structural view and a more presumptively a greater presumption against size and sort of concentration at levels that might previously have gotten a bit of a pass. So I think it's a mix of where they would like to be and what they're actually starting to do. What I don't want to try to predict exactly what's going to come out in guidelines that haven't been written yet. So it'll be interesting to see what the agency says about how they will develop their theories of harm, what kinds of, how they will view defenses. And I think that will give us a better idea of what they're really planning to do.
Great. I do want to turn to this topic of structural presumptions, but want to give other folks a chance to chime in if they had anything further on sort of guidelines purpose.
Well, I'll say one thing, which is I think that we have accumulated a great deal of evidence that we are missing problematic mergers, that we are not enforcing mergers that turn out to be harmful. And there's a large and still growing, of course, body of work that looks at, for example, efficiencies and whether those get delivered upon, and it turns out they don't really very often. And are we catching small mergers that are problematic in areas like hospitals and dialysis? And it turns out we're not doing that. And are we catching nascent competitors that are going to prove to be important competitors in the future? And it turns out we're not doing that. And are we successfully defending really obvious problems like Sprint merging with T-Mobile? And it turns out we're not doing that. And are we appropriately protecting consumers? Like, do courts understand that the purpose of this is to give consumers choice and quality and innovation and welfare? And you look at the Qualcomm appeal where the court said, we don't really care about the end consumers, nor do we care about the competitors. And then you ask, are we going to include consumers in an unrelated market? Like, are we going to have out-of-market efficiencies? And you look at American Express and it says, oh, here's a backdoor way to do a total welfare standard by including some unrelated people, namely the cardholders at Amex, and the fact that there's debit and cash paying people in the store paying higher prices is apparently not the purpose of the antitrust law. So you put all of those things together, and there's a lot more economic research that I won't list off here, but you can find it on the Equitable Growth website, for example. That just leads me to the conclusion that we are under enforcing as a general matter, and we therefore should use this review of the merger guidelines and new draft to plug those holes, to do whatever we can to plug those holes. And in light of, one could, I mean, I was on a panel with Josh Wright a few months ago, and he said, oh, let's give the agencies a couple $2 billion, and that'll fix a lot of this. You could do that, but here's where I'm going to play fiscal conservative. How about we change the rules to make it easier for the government to bring and win these cases, and then we don't need to spend $2 billion more. We could spend $500 million more, because there would be a significant deterrent effect, and the government would have less work to do. So I'm kind of all about, let's try to get us to the right answer that balances the type 1 and type 2 errors at minimal cost to the taxpayer. And I think that changing presumptions, for example, and having firms bear more of the work in figuring out what's going on is a very good way to do that. And we can talk more about that. But a number of these problems that I highlighted, you could specifically address in a new version of the guidelines.
Yeah, I mean, that's interesting, Fiona. It sort of makes me think a little bit about sort of what Howard said at the beginning, though, to the extent that, the courts are in some ways relying on the guidelines. Do we think new guidelines would bring the courts along to sort of a different view of the world? So I'm sort of thinking of the one case that everybody brings up is Time Warner, right? Where like that was challenged, right? The agencies challenged that and lost, and then ultimately it was.
Yeah, but I mean, that's Judge Leon. Really? We're going to have a conversation about revising the merger guidelines based on him? I don't know that that's a very
sure.
good make policy. And then everybody's enthusiastic about the merger guidelines until I say something like, how about we make them a little stricter because the evidence is overwhelming in favor of doing that. And then suddenly you get the response, oh, well, maybe courts won't pay attention to the merger guidelines. Well, if that's the case, then let's just throw them out. I mean.
Sure. So let's turn to this topic of structural presumptions. So, during the FTC and DOJ's Enforcer Summit earlier this month, when asked what is the most significant reform that Congress could legislate to boost antitrust enforcement, Chair Khan responded that she would like to see bright line rules that reduce the need to showcase harm. So I know, Fiona, that you've done some work thinking about this with the Stigler Center Digital Platforms Project, and one of those recommendations were to adopt rules that will presume anti-competitive harm on the basis of preliminary showings by antitrust plaintiffs, and a shift of burden to the defendant. So this is an issue that's raised in the agency's RFI. So should we have stronger structural presumptions? And maybe can you talk a little bit about some of sort of the benefits and costs of shifting the burden in that way? I mean, I'm presumably it's not costless.
I think the most important idea here is not, let's separate out shifting the burden and then on what basis you shift the burden. Mm-hmm. I'm a huge fan of shifting the burden because the way that, because we're short of resources, I think that firms that want to merge have the resources. They also have the incentives. In the Sprint T-Mobile case that I mentioned before, there were 4 law firms. The amount of money spent by the defendants in that was something like 10 times as much as the amount of money spent by the states. Okay, so if firms have that much money to spend on getting their merger approved, they can figure out where the efficiencies are, and they can hire an economist to demonstrate it, and they can make some pretty charts and generally figure out what the story is. So I think the incentive and the ability line up really nicely there, and they also presumably have a plan, so they know what it is. They can do discovery on themselves. So that seems super efficient for all of those reasons. Now, what would you use to shift the presumption and create it for the firm? I think we have enough economics knowledge to say that the mergers in more concentrated markets have increased a risk of coordinated effects, and also increased risk. The change in the HHI creates an increased risk of unilateral effects, and you see this new paper by Mike Winston and Volker Nocky, it's not that new anymore, but showing that the change in the HHI that you need to get to give yourself a decent price increase is remarkably small. So we're very far off that in the current merger guidelines. And I think so that would be one reason to do a structural presumption of that form. I think it could be useful to think about presumptions about nascent competitors. Could be useful to think about presumptions attached to certain kinds of behavior that we know are very often anti-competitive. I'm not that fond of MFNs, for example. I think that those are problematic. I'd be happy to have a presumption in some area of MFN conduct, which is rebuttable. So if there's something good happening, there are good reasons to use MFNs. You come to court and you explain what it is. And I think we just get a closer to the right answer. You asked about the costs of this. I actually am not, of course there are costs if you overshoot. My feeling is, again, the state of the evidence, and like serious research in journals by people who are being careful, is such that we need to move in the more enforcement direction, and consequently the benefits outweigh the cost of doing something like this. At some point, if you move far enough, of course, then that would tip back again, but in my view, we're not there at this point.
I don't know. Others' thoughts on structural presumptions, Bruce?
I guess the one thing I do agree that we ought to just have, as we did in 2010, thinking about all the things that are wrong with the current guidelines. And the one thing I think, as Fiona said, that we should base these changes on are, credible causal evidence, right? And the one great thing, Howard and Ginger and I probably all thought was one of the best things that the Bureau of Economics did were they've done tons of retrospectives. Their market share in retrospectives is over 50%. And one of the things, the internal validity, when the BE does a retrospective, you have to have, you have to have a control group. Mostly they're retail hospitals where they have local geographic markets, and so they're limited to what they have, and you worry about external validity. But Dan Hoskin and Orley Ashenfelter did retail, a set of retail retrospectives around the current guidelines, and what they showed was that those thresholds work pretty well. When you're below the thresholds, prices went down, and so that really just shows the Williamsonian trade-off. When you're above the thresholds, prices went up. You do have to sort of get a lot of research and evidence that's both causal and credible, but also fits and is externally valid. The thing I worry about when I look at what both of the agencies heads are doing is they tend not to talk about Woolman or Miller and Weinberg and all these things, which I think are really good works and right in sort of that wheelhouse of retrospectives and validating the tools that we use. But they go back to looking at things correlating concentration, HHI, and prices and margins on the labor side, wages. And so there's a bit of disconnect, and I worry about you could it's quite sensible to think about rules versus standards and having a much simpler rule-based system that saves resources and makes economists and lawyers and antitrust a lot poorer. Jim Miller sort of did that in the opposite way a long time ago. But on the other hand, you have to worry about what that rule is, and so I hear that maybe we have new learning, and I would be much more confident about this whatever these future guidelines are, if, the people who are running the agencies, had at least made some attempt to sort of try and garner the type of evidence that Fiona's talking about, rather than sort of just saying, oh, we know that, national concentration at the 2-digit NEICS level has gone up.
Well, let me say, I put in a ton, and I organized a whole bunch of other people to put in a ton. So it's in the public record. The evidence.
Yeah. No, and I think that's that both vertical and BE has been trying to sort of do all of that, sort of, being sort of a leader in retrospectives and validating tools. I just want to say that, everybody brings up AT&T Time Warner. Dennis and Mark and a couple other people at Compass Lexicon, they're publishing a retrospective in the JLE, and everybody mentions that, AT&T is jettisoning, Time Warner, and so their efficiencies are BS, but you didn't find RC either. Maybe
Well,
maybe,
I don't think HBO was made available to Dish anymore after that merger. So I would beg to differ with that, I think.
Okay. Well, but the point is the predictions are not that precise on either side. So.
Yeah, I think you raise an interesting point, Bruce, right? So I think about, the series of the hospital retrospective project that FTC did when they were concerned about what was happening with hospital mergers, and actually brought evidence to show that their approach was the right one, and that was really I think impactful for bringing stronger enforcement in the hospital space. So I think that's a valid point, that sort of bringing to bear the evidence that this sort of different way is needed.
Yeah, absolutely. I mean, that was, my colleague, Tim Muris. And people think about Tim and he's not, a left winger on antitrust, but I think that, what people don't understand about economists is that we're not trying to, for the most part, we're not trying to suppress merger challenges. We're trying to do some type of screening. And, as I said, the point about maybe we ought to go to simpler rules is a valid one, because maybe the screening, the benefit of the screening is not worth the cost. But, that was sort of what I envisioned as the rational way to do antitrust reform, is that, one, you learn what was wrong. Well, we were using the FTC and the courts were using the Elzinga-Hogarty test, and a form of critical loss, that were drawing these huge geographic markets. And Tim got together and said, the DOJ, the state of California, and the FTC lost 8 merger challenges in a row, and it was a way to sort of show. And, that was the benefit. I would go into, commissioner's office, and I said, well, if we let this go, we can do a retrospective, right? This is, and, Rebecca Slaughter said, if you, probably was thinking, if you say that one more time, I'm going to have you removed. But on the other hand, it's the way you learn, right? And, what I'd really want to do is sort of, a local random experiment, at the margin, but, nobody's going to do that. I think that, we have opportunities to learn, and especially in those areas where there hasn't been, according to the critics, any enforcement, and you should have a fertile ground to find stuff that you missed.
Yeah, I agree with Bruce that I think structural presumption, especially evidence-based, like in hospital retrospectives, could be useful as a device for first step risk screening. But I don't think structural presumption should replace a closer look in risky areas, especially in the places where we don't know much. Fiona mentioned nascent competition. I haven't seen very clear definition of nascent competition. However, if we shift the burden of proof to the acquirer say that's okay, we don't know what this in the competition is, but you have to prove yourself that your acquisition is not competitively harmful type of
but Ginger, I think you're essentially saying that's what you want the government to do. There's no definition of it, but the government's going to convince a skeptical court that there's a competition problem. I mean, it cuts both ways.
It is. I mean, somebody have to figure out that definition.
Yep.
If we want to look for the most cost-effective way of doing that, I'm not sure that's having the defendant spending millions of dollars in front of a court to battle on the definition of nascent competition is the most cost-effective way.
I think the problem is that these difficult questions come up, and our response for the last 30 years has been, let's not do anything. And what that means is when it's hard, we just let everybody merge. And I think that's not what the error cost framework tells you to do. The error cost framework says what you said, Ginger. Let's find the cost-effective way to make a decision here, not just it's too hard, so let's let everyone merge.
Yeah, so let's shift gears a little bit then and talk about nascent competition and nascent competitors. So we've been talking about sort of shifting the burden of proof. This is showing up in sort of recent legislative proposals concerning the acquisition of nascent competitors by digital platforms. So Senators Cotton and Klobuchar have argued their proposed Platform Competition and Opportunity Act is needed to give antitrust enforcers stronger authority to stop acquisitions by dominant platforms that primarily serve to kill competitive threats. So this idea of killing a competitive threat is also at the heart of FTC's current litigation against Facebook. Ginger, I know you've recently studied the acquisition activity of the large digital platforms. So going back to sort of this evidence-based reform approach. So are you finding acquisitions of nascent competitors or so-called killer acquisitions are really a problem? And, sort of what's your view on sort of the ability of the current guidelines to address that if it is?
Thank you, Julie. I think the short answer is we don't know yet. The killer acquisition paper by Cunningham, Eder, and Marr focus on a particular area, namely synthetic pharmaceuticals that develop molecules and target well-defined disease. And even that paper shows that only 5 to 7% of acquisitions are killer acquisitions. We don't know to what extent killer acquisitions like that exist in other markets that are much harder to define and do not face a regulatory environment like FDA approval. However, I think policymakers really need to know the answer to your question before jumping into either structural presumption of every acquisition could be a killer acquisition or require the acquirer to prove that they're not acquiring a nascent competitor in order to kill it. And more dangerously, I feel like the aggressive approach could generate unintended consequences. For example, suppose the target is developing a new technology that could be significantly differentiated or even complement to the acquirer's technology. But in order to prove that it's not acquiring a potential or nascent competitor, the target may end up stopping that innovation even before the acquirer filed the merger deal with DOJ or FTC. And it could be very costly to restart that innovation regardless of the outcome of the merger. And this could be exactly opposite to the intention of promoting competition or promoting innovations. And as I said before, I haven't seen a very clear definition of potential or nascent competition. And we got to debate on what's the most cost-effective way to figure out that definition, whether doing it inside the agency or require the defendant to do it in front of court. And we can debate on which way is most cost-effective. Right now, I'm not convinced that shifting the burden to the defendant will be the right way to do it. But I'm open to other opinions.
I would just jump in to say, I think we need to distinguish the strength of a presumption against a certain kind of transaction and shifting the burden. Those are two distinct things. And I think that one can say, we don't know enough about killer acquisitions, whether any particular acquisition falls into that category or what the impact is. We may not know enough to strengthen our presumption against such acquisitions, but what we might say is these tend to happen in highly technical, specialized areas where a small company is innovating in a way where the path of that innovation and the fit of that innovation into sort of the technology role of the time in a particular sector is information that's going to be very much in the hands of the acquirer and the target. And that may be a sound policy basis. It's certainly, to say, look, there's going to be a stronger presumption here that this is a technology that could compete with yours. So we're not saying it definitely does. We're not saying you have a mountain to climb, but come in and show us that it doesn't. And I will tell you that is effectively happening in a number of these kinds of investigations. And I don't think that's necessarily a bad thing. When you see, some kind of new therapy or biotechnology tool that could lead to a new therapy coming into the market being acquired by a leading firm that already has, for example, a conventional therapy, you want to know, is this something that could grow and compete against you? Are you going to kill that off for cannibalization effects? I don't think these are unreasonable questions to require the acquirer or the target to answer. I do think that one has to be careful, though, about sloganization. And there's an unfortunate tendency towards that in some of the current competition law debates and competition policy debates. Just because there's a small innovation that is in a particular sector being acquired by a large platform, we shouldn't presume in any way that that particular acquisition is a killer acquisition. And very importantly, nor should we presume that it is a bad thing to have large platforms or large companies. I don't want to just talk about tech platforms, but large companies in any sector acquire small startups. I think there's something we need to know, and that needs to be modeled and examined. On the one hand, as is commonly said, that exit path of an acquisition by a leading firm incentivizes a lot of innovation. Not all, but it does incentivize a lot and incentivizes the funding of that innovation. On the other hand, it may also bias the direction of startup innovation in a way that we don't get whole areas of innovation that, if there were not that exit path, so that you weren't innovating towards those dollars in that exit path, we might get a broader range of information, I think, of innovation. And I think we do not know enough about the trade-off between the benefits and incentives of the exit path and the biasing of the direction of startup innovation. I can tell you from personal experience that college kids aren't necessarily thinking about where they can sell their innovation. They just want to build cool tech. And then they get a cold dose of reality when they go out there and they try to get funding to build their cool tech, because the people behind the money say, okay, but you're never going to grow up to compete against X. So where do you fit into their tech stack so that we think you have an exit path? And that is a little bit of, in some sense, an unfortunate effect. So I think we need to learn more about the incentive effects versus the biasing effects, and not assume that the innovation that we see out there is the same innovation or even better innovation that would result if people were innovating to stand on their own rather than to be acquired. And I think that's a whole area of research that we need to learn a little bit more of before we adopt presumptions. But again, I want to be clear. I think that's a different thing from requiring acquirers and the targets to answer some questions.
So I like that you raised this point, Howard, the breaking the news to the college student that you're never going to grow up to compete against whomever, right? But that's sort of the narrative that's out there right now, is that but for these acquisitions, that they would grow up to compete against X. And so I just wonder, like, what's the trade-off there then? So now we don't have this innovation at all.
Well, look, first of all, let me disclose that I provided legal advice to Facebook when they were being investigated by the Federal Trade Commission. So I have some insight into at least a couple of very specific cases of this, but I'm not going to talk about those, obviously. And I'm not their trial counsel, but let me. Here's my view. I think that there are cases where there are acquisitions where a company could have grown up to compete or provide a meaningful differentiated product that is at least partially an alternative for a set of consumers, therefore broadening consumer choice, broadening the number of entities that are out there innovating. I think that I can think of numerous cases where I think that mergers were allowed to go forward where that would have been the case. Don't have any clear evidence. I just have a strong sense. But I think in any given case, that can be a very difficult thing to understand, a very difficult thing to prove. I think at the time a transaction is occurring, and there is some reason to believe that there's a growth trajectory and a technological robustness that really could lead to harm. I think there should be a very rigorous even if there isn't a current overlap, but a predictable one. I think there should be a full and rigorous investigation, and I think there is a case one could make for a burden shift. I do worry about hindsight in this regard, because I think it's very easy to turn around and make casual observations about what would have happened because of what in fact did happen as a result of the merger. I think there's a real risk there of actually conflating the very things we hope a merger will achieve with harm. So, I think looking at acquisitions that might have very small or even no current overlaps at the time they're occurring in a very rigorous way is a good thing. Antitrust should do that. Enforcers should have the tools to do that. And just because enforcers, I really want to emphasize a point Fiona made, don't have answers to all of the questions, doesn't mean that they should be disabled from requiring the parties that have better information to answer those questions. I think that's an important thing, and I think it's good that policymakers are looking at that. But again, that's something that I think one can do that could improve antitrust enforcement without adopting stronger, rigid presumptions against those transactions. And again, I think when those transactions are being looked at in hindsight, they have to be handled particularly delicately.
Let me say just a couple things about the whole innovation path. What Howard said about the path of innovation and the type of innovation is really important. Let's think about what the internet would look like if there had been no Microsoft case, for example. I mean, these are decisions that can have huge impacts on consumer surplus and the nature of investments in technology. So what we really want to do is block transactions of substitutes and allow transactions of complements. It's quite difficult to figure out who's a complement and who's a substitute, and who's likely to know that? The firms themselves, much more than the government. So I think this is, again, the incentive and ability part counsels for having firms having some role here. But another thing that really matters is if we don't enforce in this area, what do we get? We get investment by people who are going to come in to exactly compete with the incumbent in order to be bought so they can share in the monopoly profits and get their payout that way. And that is not socially useful innovation. That's like pay for delay in another way, okay? And that doesn't help us, and we don't want to stimulate that kind of innovation. So when people say, oh, look, there's lots of exit strategies, you have to be really careful. If you're not enforcing and you're inducing entry of a thing that's just looking for a payout, then that's not helpful. A second thing is that if we have the guts as a society to ratchet up the dial on enforcement a bit more, because we realize that we haven't been doing a very good job, we're probably, because of the nature of these kinds of things, going to enforce a little harder both on mergers and on monopolization. That means that the small entrant coming into the market has a second path to money. They could be bought, but they could also perhaps succeed in not being squashed by the incumbent and grow and have their own revenue rather than being purchased. And so that's another exit path that should be on the table when we're thinking about, as a society, how do we stimulate innovation? I'd really like there to be entrants coming into search and social networks and e-commerce and things like that. And if we're not enforcing well, we're not going to be getting those entrants.
Great. So I want to turn to one more topic, which feels a little controversial lately, which is the benefits of mergers. But before we do that, I just want to remind folks that are watching, if you have questions, you can go to slido.com, #ITIF merger guidelines, and we'll ask some audience questions at the end to the extent folks have them. So like I said, I want to talk about benefits of mergers. So the agencies have taken several actions over the last year, such as suspending early termination, issuing these close at your peril letters, reinstating prior approval and consent decrees, which really suggests a new hostility towards mergers. I've noticed even a shift in the language that enforcers are using. So instead of referring to proposed mergers as potentially anti-competitive or as harming competition, enforcers now talk about illegal deals or illegal transactions. So this hostility might lead one to conclude that enforcers do not see any benefits arising from mergers. So I was hoping maybe, Bruce, you could talk a bit about what you see as the benefits of mergers. I'd be particularly interested sort of in continuing this discussion on innovation that we've gotten started here, given your research on this topic. What's your view on sort of merger benefits in particular as they relate to innovation? You're still muted, Bruce.
Yeah, they always tell you not to allow your dog in the room. Well, I have a Saint Bernard, and he's snoring. So, sorry. The topic of well, there's two really topics here. Is three. There's one is that people are just saying illegal merger. My favorite example is Pueblo Bolomat versus Brunswick. I love that case. One, my wife grew up about 3 blocks from the Pueblo Bolomat, and I've actually seen it and touched the wall, but I wouldn't go in because, I mean, there you really do have sort of an example of one of the primary benefits of the merger, right? Brunswick made bowling equipment, and they bought a bowling alley in the north side of town in Pueblo, the Belmont Lanes. Because they had put in all their equipment, they put it in, and they give the bowling alley credit, and the bowling alley fails, right? I don't know whether it's somebody who didn't grow up or what, but and what Brunswick did, they became one of the biggest nationwide operators of retail bowling centers by basically saying, okay, you owe us a bunch of money, why don't you just sign over the lease? Right. And one of them was Belmont Lanes in Pueblo, Colorado. And the guy who owned the Pueblo Bolomat, it's now called Big Daddy Sunset Bowl, still there, sued because he under the antitrust laws, the Brunswick buying the Belmont Lanes was an illegal vertical merger. And this goes up to the Supreme Court, and the Supreme Court finds that it was an illegal vertical merger. However, the guy who owned the Pueblo Bolomat and other bowling alleys couldn't recover because the Clayton Act only gives you remedies if you're recovering for the type of injury that the Sherman Act and Clayton Act was set out to set that activity that's forbidden by these laws, and so one of the things that you see is that here the merger preserved competition, right? Mergers also, if you do the Williamsonian trade-off and the efficiencies outweigh the upward pricing pressure, horizontal mergers produce downward pricing pressure, and vertical mergers, as part of the unilateral effects, you could have downward pricing pressure even in the absence of efficiencies. So mergers can, just in sort of the terms of prices with a static demand curve, increase consumer welfare if you have efficiencies, or in the vertical merger you have downward pricing pressure outweighing the upward pricing pressure from RRC. And so you have that. You also have sort of a second issue, which, the first time I ever went to a party meeting as bureau director, I think the first thing that came out of my mouth was, well, can you talk about the efficiencies? And people spilled their drinks on the floor. It was like, I said so, and they were totally unprepared. This was, a bunch of geographic locations, and the overlap was a really tiny strip. And I thought, this is like, Miller Coors, right? That I was a systems engineer as an undergraduate, and I said, yeah, you do operations research, you do the transportation problem, and you figure out, what the savings are when you own, a bunch of other plants. And I think one of the problems with efficiencies under the cognizable and specific to the transaction way in which they deal with it, the agencies say never find that they're cognizable, or the lawyers, or specific to the transaction. And I think the standard by which you judge that is asymmetric. And if you do burden shifting under Baker Hughes or just generally in the agency, it's really hard to sort of prove these things because they're often speculative, and they often sort of turn the inquiry into the world that Coase was railing against when he wrote his famous 1937 piece on the nature of the firm, is that, you could just do it by contract. And so I think if we were going to sort of do burden shifting and presumptions about illegality within the agencies, not just when you go to court under Baker Hughes, I think what we have to do is we have to think a lot more about, efficiencies, including the parties and including sort of the antitrust bar, because I just don't think it's something that they do very well. The problem, not only with innovation mergers, but also with nascent competition, actual potential competition or nascent, is that, I mean, if we do a merger between two office supply stores, right? We have sort of this assumption about past is prologue, right? It's that, the existing competition is going to sort of be a good measure empirically for what the post world would be like without a merger. And then we just have to do something. In Staples Office Depot in the 90s, they did a natural experiment, entry-exit model and estimation. There you have one counterfactual that you measure, and then you try and find a way to measure sort of what the merger would do. In nascent competition, in actual potential competition, in innovation mergers, you don't have sort of the past as prologue assumption to rely on, and so you have to do two counterfactuals. It's really hard. It's really going to be error prone, and Fiona says, like, let's do something. I don't know what to do. I mean, I'm a bit humble about that. And so if you start doing stuff, I need to know sort of what the empirical basis for
Bruce,
what you're doing.
doing something, I mean, not doing something is a choice. It's
Yeah, no,
just
I understand.
you can't
I completely
escape the
agree.
problem
Yeah.
by saying, I'm humble, so I won't do anything. That's just saying, I'm letting everybody merge. That's my choice.
Yeah. And that's one choice. And I see it as equally generating equal cost given my priors and as
I mean, that's just not what the error cost model tells us to do. That's the problem.
It could be, right? I mean, if I have diffuse priors and you have equal error costs, then it is, right?
Then sometimes we'd have to do something.
Yeah,
if we had equal error costs.
I mean, maybe you could do random I mean, truly random, right? Just truly random enforcement. I said that to Joe Simons when he asked me to do the job, and I said, "Yeah, you want to learn stuff? Let's randomize what's indexed." And he still offered me the job. Yeah, but it is a really hard problem, and I mean, I wrote my dissertation on patent licensing and innovation, and one of the problems there, I mean, when I was going to grad school, the big problem was, we have too much innovation or too fast innovation, Disculpa and Stiglitz or Jorm Barzell's old paper, and we don't know whether more innovation is better than less, right? And it's a very hard area, and there's nothing you can rely on to predict. In antitrust cases, they become documents cases. I mean, I was on a panel with David Teese, and he was yelling at the economists. He said, "It's your fault. We can't do these because you haven't paid enough attention to sort of innovation and stuff." And people tried, but it's hard. I mean, Harold Demsetz was on my committee, and he signed my dissertation. And he looked at me and he said, "I've seen a lot of people who are a lot smarter than you, Bruce, just bang their head against the wall trying to do this area. And so publish your dissertation and get out." I mean, that was his, and he wasn't trying to insult me. He was just, I mean, it's just a very hard area.
But we don't have to know everything.
If economists are having problems, enforcers are going to have problems too. And so I don't know how you're going to. You could do the error cost analysis and say we ought to do more. It's just going to be generating a lot of error costs. If you don't do anything, it's going to generate a lot of error costs.
Yep, fair. I mean, I think that what I'm hearing in the policy environment now is a desire to get away from economics, which I find actually driven by a misunderstanding of what economics does. I think attorneys think that if it's a Greek letter or a number, it's economics, and otherwise it's not. And people who are actually economists understand that an email that says, if we make the following choice, then these will be the consequences, are telling us about the information set, the game, the agents, the payoffs, and all of that actually is economics. So I think that the way we have to go in a world where we don't have a model that says, here are the 6 things that will be invented in the absence of this transaction, and their characteristics and their prices, which is really not a tool we have in economics at present anyway, that you need to go with the kind of economics that's lodged inside the documents, in particular documents of the people in charge who are making a strategic plan for the corporation. So if the plan is, well, it's easier to buy than compete, or if we buy this firm, then we don't have to worry about future entrant, those kinds of analysis are maybe really the model that we have and the evidence that we have, and maybe we have to run with those in the absence of something more specific and detailed.
That's a really fair point, Fiona. I mean, I've seen in documents where basically a financial advisor in words said what the diversion ratio was, right? Like they didn't set out to calculate the diversion ratio, but they kind of said, hey, if this happens, then this will happen. I was like, oh, that's the diversion ratio. So yeah, it's not all numbers in Greek letters.
That guy did not use any part of the Greek alphabet in his explanation.
Okay, but that's something that's way different than using presumptions that are not based on sort of, credible evidence. I mean, I think that's right. I mean, the FTC, and this isn't Lena Khan's FTC. This was, pre-Lena brought. I mean, Fiona knows, a case Illumina Grail, right? And they got 5 votes, right? I think 5 or 4. And there are. I mean, that is an evidence based, and I mean. What you don't have is a lot of purchase with the third leg of the stool, which is the economic evidence. You rely on the testimonial and documentary evidence, and I'm fine. I mean, that's a standard way that the agencies have done innovation cases, and in sort of retail mergers, you have the third leg, and I think you have a lot of contributions. I agree with Fiona. I'm just sort of shocked at what people say about economics. There's that withdrawal of the 2020 vertical merger guidelines. Whether you thought those things should have been withdrawn by the FTC or not, the reasoning is the most troubling thing, right? They have some. If they were in my antitrust economics class, they would have gotten an F. Somebody sent me a speech that John Canner wrote, and he was saying that what economists do is try to estimate things down to the 8th decimal, and he's an experienced antitrust lawyer. That's not what economists do, so I think what they're trying to do is a caricature of economics as sort of this useless just this useless thing that costs a lot of money. And I think that when I talk to economists, which I disagree with a lot on sort of baseline policy and where you draw the line and stuff, the great thing about economists is that most of us are using the same paradigm. Error costs, we may have disagreements about how you treat sort of the cost of errors or the frequency and how you interpret empirical evidence, but it's the same basic paradigm. And I think what they're doing is just sort of trying to ditch it all over the side.
So let me key into something you just said there, Bruce. We do have a couple of questions from the audience that are really sort of the same question. I'll turn to that in a minute. Your characterization, or I guess your characterization of their characterization of economics as this useless thing that costs a lot of money. I think this ties in sort of to that point that I mentioned earlier about Chair Khan's statement at the Enforcer Summit. One of her reasons for wanting these sort of, as she called them, bright line rules or structural presumptions, is that in her view, she doesn't have to then go hire a bunch of very expensive economic experts to bring cases. So I would love to hear, all of your thoughts on like what's the role for economists if we get these bright line rules in the next sort of turn of the guidelines.
All right, I'll go. I think you got to do the work behind the scenes to figure out whether you think the merger is a problem or not. And that might be considerably more sophisticated because you're not worried about explaining it to a judge. You're just worried about getting the right answer. So there's all of that, I think, which is really important. And then, again, if you only think that economics is estimating a giant model with an enormous team and a huge data set, that is very expensive. But if you think that economics is about figuring out the locus of competition and the dimensions of competition and the nature of competition and the timing of competition, a lot of that comes from the documents. It doesn't necessarily have to be very expensive. Once you have an insight into how competition is working in your setting, then perhaps there are some relatively simple ways of collecting evidence that bolster that interpretation or would weaken it, and that would be helpful to know before starting to bring a case or defending a case. And I don't think economics has to be expensive. At least the way I do it, it doesn't have to be expensive. It depends on what you're trying to achieve and the kind of data intensiveness of the situation. I'll stop and let the other economists chime in.
Well, how about let me give a lawyer perspective, since I think I'm the only one.
Both hats.
Yeah, I think I'm the only one of us who also wears that hat. There is work for economists to do because the law has not changed. I know that there are people currently at the top of the agencies who would like to see a per se rule against mergers, but there is no per se rule against mergers, and one might be able to argue that Philadelphia National Bank is still good precedent and has never actually been overruled, although General Dynamics and some other cases certainly kick some of the legs out from under it. But the FTC cannot and the DOJ cannot in guidelines turn what is a burden that they currently carry to show harm into a per se presumption against any particular merger, no matter what the concentration level is. Now, they might not have much of a burden to carry when it's a 2-to-1 or a 3-to-2 in many cases, but they are ultimately, no matter how strong the presumptions in the guidelines are, going to have to say that not only is this something where we get a presumption of harm, but there actually is a reasonable likelihood that there will be a substantial lessening of competition, or, as you know, the phrase, the part of the statute they are currently focusing on, tendency towards monopoly, which again has a lot of definitional questions. So there will be roles for economists, both at the agencies and outside, to say, look, even with a stronger presumption, you still have to show a likelihood of effect. You get a little more of a boost and a little more of an acceleration or a downhill, push on that from a stronger presumption. But you have to convince courts, even, first of all, that you really should, that the presumptions and the guidelines deserve judicial adoption. I think you'll get divisions in the courts on that, but you already do get divisions in the courts on that. But ultimately, the parties are going to bring economists in who say, despite that very strong presumption against our deal, we can actually show you the presumption is rebutted. So both parties and the agencies will need economists. But I really want to emphasize what Fiona said. The current caricature of economics is deeply unfortunate because it, to me, is a mask for not wanting to do some deep and rigorous thinking about an analysis of effects. And whether you call that rigorous analysis of merger effects or economics, to me, doesn't really matter. Economics is a set of tools that people use. Now, can economics obfuscate by virtue of its infrastructure and technology? Sure. That is why you get judges throwing up their hands at massive econometric models that show up on both sides. But there are lots of ways to do good economics and contribute meaningfully to the rigorous analysis of a merger that come short of that. And Fiona has done that in numerous places where she's testified. I think Sprint T-Mobile is an example. I think there are others where you see clear, logical explanations of harm, tying it to the facts of the case, tying it to the conditions of the market that don't require a lot of technology and infrastructure. Economists can help with that. They can also use those super rigorous tools behind the scenes and take the results and explain them clearly. So I think there's a little bit of a burden on those of us in the economics profession to explain more clearly and to tie our explanations to facts other than often flawed data sets. But there will be a role because the law has not shifted to a case where the FTC can come into court and say, two of the top 5 firms have merged to a 33% market share. Philadelphia National Bank, undue concentration and tendency towards monopoly, we're done. Because they'll point to General Dynamics and say, if there's anything at all that the parties can bring to bear, saying that current static market shares aren't the right picture of the market, you, the FTC, can't stand on your market shares. What's your evidence of effects? So I hope they continue to have a robust group of economists at each of the agencies. And I think that I don't think that the economics profession, insofar as it works in the antitrust sector, is likely to be out of work anytime soon.
Great. Thanks, Howard. Do you have anything to add to that, Ginger?
Yeah, I totally agree with Fiona and Howard on the unfortunate miscapitalization of economists. Now, I feel like the benefits of merger guidelines is to instill rigor in terms of here's a understandable theory of harm for merger, and here's some basic way of collecting evidence to support or go against the merger. I feel that's the strength of guideline, not the flaw of guideline. And if the guideline need revision, I would push for more of that in maybe, say, long-term consideration of dynamics or non-price effects, those areas that we have seen potential problems. I feel like those are the areas exactly that need more rigor from either economics or whatever you call it, rigorous legal analysis, not less.
Great. So we've got a couple of questions. Howard, you might be best placed to take these. They're really about timing. So in terms of when we can expect new guidelines, when do those new guidelines apply? So I don't know, maybe you can speak to your sort of past experience of how this process works, of what the timing might look like. Oh, you're muted, Howard.
Thanks. I think that, there are a lot of comments that have come in, and I think, even though this isn't a formal regulatory process, I think the agency will want to take those into account. They'll want to rigorously justify what they put out. That's going to take some time. And then there will be a circulation for vote, at least at the FTC. That has been the process in the past. And so, I think they'll take into account the public comment that they're getting. They will draft the guidelines. Hopefully they will put them out again for a round of comment, which is what was done in 2010. And then that comment will be taken into account. So this is something that could take several months. They become effective on adoption. So they would become effective immediately. And I think what people need to understand is there's nothing to stop the agencies from effectively acting on the draft guidelines in advance. These are not things that have the force of law. You're not bound by the administrative law requirements to, have published and gone through a bunch of APA compliant procedures before you actually shift what you're doing. So I think once the draft guidelines are out, I would expect to see the agencies behaving in accordance with them if they aren't already. And where are we? We're almost May. I think it's not impossible they have these out by year end. But I'd be surprised if it was a lot faster than that, because that would suggest a somewhat truncated public process. But sometime fourth quarter of this year, I think is a good possibility.
I mean, don't you think that a lot of the comments that came in were things that were already known to people who specialize in this field? I mean, if it were me, I would have started writing the thing ages ago. And then, of course, I would be looking at the record and making sure I had seen everything that was in there. But if you've done a good job, you ought to have seen most of the stuff that's in there. So I would hope it doesn't take that much longer to absorb the new stuff.
No, you may well be right. And then, I do hope they put what they draft out for a round of public comment, because, there could be, an overweighting of a particular type of comment. And I think, that's the kind of thing that it is at least beneficial to have that viewed and called out. So it will be interesting to see what they do. They could be very fast if they wanted to. But it seemed to me that to be faster than, the end of summer, early fall might call into question the integrity of the process.
Also conditional on getting a fifth commissioner, but that seems likely to happen soon.
Or write good guidelines that get, 3 of the current 4. But yes. Point taken.
Yeah. So we're about to wrap up. Any parting thoughts before we do?
This was fun.
All right. This was fun for me too. Like I said, offline, it's great to have a chance to talk to some of my favorite people about sort of nerdy antitrust things. So thanks to you all for agreeing to be part of today's panel. And thanks everyone who's tuned in.
Thank you, Julie.
Thank you, Julie.